A no contact order is one of the easiest court orders to violate without even realizing it, and one violation can be a brand new criminal charge. So what is a no contact order? A no contact order is usually issued in a criminal case, and it protects one party, typically a victim of the case or maybe a witness, against the defendant who's charged in the case. The no contact order covers direct contact if I were to reach out to you, or indirect contact if maybe I put something online and tagged you in it, or if I told someone to reach out on my behalf to you. So even that indirect contact counts as contact for the purposes of a no contact order. So what about a protective order? A protective order functions very similarly to a no contact order, but it comes out of a civil case. So a no contact order is typically attached to a criminal case, where a protective order is often from a civil case, or it can be its own civil matter. You can file for a protective order, or sometimes they come from a family law case or something like that. But it functions the same way, in which there's a protected party who the person the protective order is served on is not allowed to have contact with, and that includes direct or indirect contact. So what counts as contact? It can be a lot of different things. It includes texting, calling, email, social media messaging, having a friend send a message on your behalf, showing up at their work, their home, their school, where you know they're going to be, leaving notes, gifts, letters, sometimes even reacting to posts with a like or something like that can count as contact, and that's what we want to avoid. One of the common questions we get is, well, they contacted me first, so it's okay. No, that can still be a violation. If I have a no contact order against you and I reach out to you and you respond, you have violated the no contact order. Now, a lot of times we can explain that situation to the prosecutor, but it's still the basis for a new charge or a violation. It's something we want to avoid. So if you know there's a no contact order, and even if the other person wants it lifted, do not respond. Reach out to us so we can try to figure something out to get that lifted if the other party doesn't want it in place, because responding can be a violation. So why do these violations happen? They usually happen because of emotion or panic or guilt, or trying to fix it, or reaching out to the person just for whatever reason, and you don't want to do that, because the court is going to view any violation of that no contact order as a direct violation of a court order. If you're out on bond, they could revoke your bond for that reason. They could file a new charge. They could impose some sort of penalty. It could be a probation violation. Whatever it is that led to that no contact order, if you violate it, you are setting up much bigger issues for yourself. So what do I do if I need to contact the person? If you need to communicate, for example, about the kids, property, housing, something like that, ask your attorney what you can do. In some instances, there are applications that the court will let you use, especially when it relates to family law matters, where you can communicate only about the kids or things of that nature through an application where that communication is monitored. But whatever it is that you need to talk about, reach out to us, because we can try to figure something out that'll work for you. If you have a no contact order or a protective order, or you're not sure, what the status is, and you don't know what to do, give us a call. We can help you navigate that tricky situation, and we can see if there's some way to get it lifted and get contact back in place if that's what the other party wants to do. We help with that all the time. So give us a call at 317-632-3642, and remember, always plead the fifth.